Legally Speaking with me, Tarun Nangia. We are going to discuss a very, very important judgment today. This is authored by Justice Vikram Nath, Judge Supreme Court of India, and Justice Prasanna B. Varale, Judge Supreme Court. And this is about judgment that was delivered by the Competition Commission of India in the case of Schott Glass India, that was overturned by the Supreme Court. And the allegation against that company was that it is a dominant supplier of borosilicate glass tubes, and it was guilty of abusing its dominant position by offering volume-based discounts and some other things. Basically, abuse of dominance was the criteria, and the case against them and the allegations were made by the complainant Kapoor Glass. Why this judgment is important, what all we'll take away from this judgment, we will sort of know from Senior Advocate Percival Bilimoria, who argued this matter. Good to see you, Mr. Bilimoria, and looking forward to your insights. And for understanding this judgments from the judicial point of view, how it will impact the industry, what will the overall impact on the economy of such judgments. We have Justice Arjun Kumar Sikri with us. We all know he's a leading arbitrator. He served as a judge of the Supreme Court of India. He served as a judge of the Delhi High Court. Before that, he was also judge of the Punjab and Haryana High Court, and continues to currently serve as sitting judge at the Singapore International Commercial Court. Good to see you, sir, and thank you for your time. And looking forward to your insights on this topic. At the outset, I'll go to Senior Advocate Percival Bilimoria. Mr. Bilimoria, congratulations, first of all, for that victory. And also, we would like to know the takeaways on this matter. What do you for this?
Thank you, Tarun. What a privilege to be here with Justice Sikri, who has, in fact, when he was on the bench, authored several judgments on competition law. And in fact, in these proceedings, I had the opportunity to base my arguments on a couple of the judgments of Justice Sikri. So I'll touch upon that as we go on. The matter essentially was about, as you put it, Tarun, abuse of dominance. So if you remember in the old MRTP Act, there was a concept of a monopoly, which essentially said that you cannot be, your size of assets or, your very presence in the market cannot be so huge that you are a monopoly. And monopoly was, of course, defined in slightly different terms. The new law, Competition Act, is more contemporary. It follows I always used to say that, look, we don't have to reinvent the wheel, because the jurisprudence on competition law has been set from time immemorial, started in the US, and then the EU took it up. So there is a concept of dominance, not really a monopoly, but a dominant undertaking. And it is only abuse of dominance that is a contravention of the law. The very fact that you are dominant is not necessarily a contravention. It's only when your market conduct is such that you are using that dominant position to, your conduct is representative of certain acts to exclude competition. So, for example, you are preventing other competitors from entering into the market. One of the criteria, and this is Section 4 of the Act, which talks about abuse of dominance, is in Section 4. And the reason why this judgment is important for the future is it sets out the basic principle that in evaluating Section 4, it's not just when there is an allegation of abuse of dominance. Of course, the abuse of dominance has to be established with empirical evidence, but there is also the test of justifiable, there's an economic justification. Now, this test again has been used in foreign jurisprudence. It has been recognized. I think this is the first time that our Supreme Court has recognized that there can be an economic justification. So there may be market behavior, market conduct, which someone will say, okay, this is an example of you abusing your dominance. But the act, as well as this excellent judgment, recognizes that there could be economic justifications to that conduct, in which case you cannot be said to have abused your dominant position.
Point very well taken. And I would request you, Mr. Belimoria, if you could give a summary of the judgment in a minute, and then I'll go to Justice Sikri for his analysis.
Right. So this is one of the main findings, and I think this will also impact future cases on abuse of dominance. There was also one more issue, which is that the allegations, by the CCI, there was a requirement, there was a request for cross-examination. So if there is some competitor who is inimically opposed to me, obviously because of his very nature that he's a competitor in the market, and if that competitor gives a statement to the CCI, you cannot condemn me merely on that statement. I have to have the right to cross-examine. So even when the compact, in those days we had the competition tribunal, now it's the NCLAT, but when the compact was hearing this decision, it set out in Schott Glass that yes, there is a right of cross-examination. You cannot just rely on statements from parties who are naturally inimically disposed against me. So these statements essentially said that, look, Schott India, which was a subsidiary of Schott GmbH, the indirect subsidiary, was selling goods to another related party where it had a 50% stake. And that sale was at a discriminatory price because they got a higher discount. So one of the examples of abuse of dominance is discriminatory pricing. And we argued successfully before the compact and now before the Supreme Court to say that, look, there was a reason for that discriminatory price. And the reason was that the volumes that were ordered, demonstrably so, the volumes that were ordered far exceeded the volumes that would be ordered by any other competitor who were incidentally inimically opposed to us. So essentially, the guideline that comes out now is that a volume-based discount. So if Mr. X is ordering X Y quantity and other parties are ordering 10 times Y quantity, then the other party is ordering more quantity, which is a volume discount, are entitled to a discriminatory price. I mean, I need hardly say that it is common sense, but unfortunately, this is something that was not very clear at that time.
Okay, thank you. Thank you for your opening comment. I'll go to Justice Sikri for his analysis of this judgment by Justice Vikram Nath and Justice Prasanna B. Varale.
Yeah, Tarun, first, good evening, and good evening to Percy also. And kudos to him for getting this wonderful judgment from the Supreme Court, and to the honorable judges who have really, given this remarkable judgment. Let me tell you, and I'll come to that, my emphasis is going to be entirely different, although it is captured in the judgment as well, and how I see this judgment to be of prime importance from that angle, because the issues can be decided and they are decided in a particular case. So case to case issue would be decided, that may not have much relevance. But what is the most relevant factor behind this judgment? So I'll highlight that. But before that, I take a step back, and since many viewers on this channel would be those who are not have legal education, or may not be even some of the lawyers, etc., may not know much about the Competition Act. So I'll preface some of the concepts under the Competition Act, and then I will mention how this judgment is really outstanding, and how it becomes a milestone. You see, as the very name suggests, Competition Act, and as Percy has already mentioned that it was replacement of earlier our MRTP Act, Monopolistic and Restrictive Trade Practices Act. And the reason was, look, when we ushered into the era of globalization and liberalization, and when we wanted the foreign direct investment to inflow, even the technology to come back to this country so that the country can prosper and can make economic progress and economic strides, etc. And it has really succeeded. We have succeeded in that mission in last 30, 40 years, 30, 35 years, because 1991 it started. But then another thing which was happening simultaneously, since to give comfort to the foreign investors and those companies who would give us even the technical know-how, etc., that our laws also should be compatible with what is happening in the world, and they should be, as we say, compliant with the universal or global standards. And because of these reasons, many laws were passed. And this our archaic law of MRTP, which was, I think, of 1957 or so, had totally outlived at that time. And that was really like which Percy has said that, look, it only said that there can't be any monopolies created. So as it says, monopoly and restrictive trade, either their trade practices which are monopolistic in nature or should be restricted, etc. So that was the aim. But now it was to go ahead with the or along with the global trends. So what was the purpose of this act? Yes, prime purpose, which is again was taken from many jurisdictions abroad, and as again I would say Percy has already mentioned, US has been championing this, and because it was the jurisprudence which had developed there for last many years, 50 years, 100 years earlier, and they call it antitrust laws. And the way it developed, you see, the prime thing or the motto or the, I would say, message behind this act is that we have to give, necessary support to the competition. There should be healthy competition among the industries in the country, or even country vis-a-vis maybe multinationals, etc. Because healthy competition has many advantages. And particularly it aims at and which is stated in the preamble to the Competition Act also, that it is for the benefit of the consumers who get better services, who get better goods. I give you one simple example. If you remember, when the cell phones were introduced in 96, 97 or so, we used to have this, if you want to make a call, 16 rupees per minute was the charges. But when this spectrum were given, the licenses were given, and to many companies, the government started to give. Initially, they were in the segment, okay, for North India or for Delhi, X company will be given, for Bombay, this company, this, that was the first thing. But thereafter, many companies were allowed to operate in multiple, same jurisdiction. And this competition, only today, if you see, from 16 rupees, it may be, I think, few paisa, 10 paisa per minute. It has dropped to that. And virtually, the calls are almost free, and it is the data which is sold by the companies and on which they are able to earn. But that is one I wanted to give you an example, is the result of competition. And therefore, competition is encouraged. And in order to, and therefore, this Competition Act aims at three things. One is there should not be anti-competitive agreements. That is, that many times and that is what antitrust laws are, that there should not be what we call in our common language creation of cartels, etc. That two companies come together, they have an agreement, okay, we will both agree that we will not, although they may be competitors, they are producing the same product, but yes, we will not reduce the price below this X price. So both of them agree. and therefore nobody is going to be affected, but consumer is affected. So such competitions are not permitted under this. They are frowned upon, and there are penalties for that. Other is which this case relates, is the abuse of dominant position, to which I will come to. But the third is that mergers, again, or we say amalgamations and mergers, that if the big companies start merging, then they will again create monopolies. So which therefore they have to go to, it's not that they are not allowed, but they have to go to Competition Commission to seek permission. If you remember, I again give you an example. There are hundreds of such examples, was that recently Air India and Vistara, because after Tata's bought Air India also, they have now merged. But for that merger, in order to get this approval for merger, they sought the permission of Competition Commission, and Competition Commission looked into all this, that they are not going to be monopolistic in nature and therefore becoming dominant in the process. So, and now I come to the abuse of dominant position, which was the central theme of this judgment. Now, dominant position, that tests are laid down under the act, that who will, depending upon the market, what market and the sector in which you are, what is the market of that, and then they will see that how much influence you enjoy in terms of the production which you have, in terms of the market share which you have in that particular market. So on that basis, whether you are in a dominant position or not. So that there are big companies, maybe today, let us give a very simple example. If it comes to, and it is in America, in any case, Google. And if the services which Google provides, Google is in a dominant position in that market because they have larger share and therefore they command. But what the act recognizes, which Percy has said, and that is very, very important. And now from that angle, I come to this judgment, that although act says so, but how it is implemented. Now, dominant position by itself is no taboo. There may be dominant positions which may be enjoyed, but whether the person who is in a dominant position, that company, that enterprise, who is in a dominant position, whether it is abusing that position. So it is the abuse of dominant position which is, frowned upon, and which becomes objectionable. So dominant, and how it can be abused. That there are 5 forms of abuse, if I may say so. Unfair pricing. So since I am in a dominant position, I know 80% say services or goods I am catering to, so I have a right to this fix any price and people will buy. So, but then I start fixing unfair pricing if that number one. Number 2, limited protection or technical development. So in order to make myself relevant, not only relevant that in that dominant position, so I intentionally do not produce much, so that the market is always, there's a demand is more, supply is less, and they are always looking at me. So therefore, this is again treated as abuse of the dominant position, or limiting the technical development also of that particular project. I don't want to make further advancement, further improvement in that project, because whatever I produce, people are going to buy because I'm in a dominant position. So third is denying market access. If I deny market access to somebody and they say, these persons, I'm not going to sell my goods, or this category, I'm not going to sell goods. And when I select my retailers, etc., for that purpose, so I deny some of them. So then it becomes abuse of my dominant position. Or imposing unrelated tying obligation. I say that, look, if you purchase from me this thing, the other byproducts which you need to produce that, you will have to buy from X company, which may be my subsidiary company. So I say buy from that only. So these are tying obligations. So I impose on them, or leveraging dominance from one market to another. If that is done, then it amounts to abuse. And therefore, now what happened in this particular case was, as you have also mentioned in the beginning, and Percy has said, there were 4 or 5 kinds of categories of activities, I may say, or the actions of that company, which were by that Kapoor, that company, that they were the complainant, that said that these are abuse of the dominant position. Now, to cut that controversy short, the court has gone into each of those allegations and have found that they have not been substantiated. So on facts, the court says that no, there is no abuse of dominant position. And what Percy said about that bulk discount, if I may come to that. So bulk discount, a person who is purchasing the discriminatory discount, I won't, because discriminatory, common man would understand as if they were discriminating, giving lesser to some and higher to other. In that sense, it may be discriminatory, but was not that. If you go to market and you are buying, and the shopkeeper says, okay, if you buy 100 units, I'll give you 10% discount. If you buy 150 units, I'll give you 15% discount. So this is 10 to 15% is so-called discriminatory. But as we know in our legal language, also in the Constitution, also Article 14 says, although it is a right to equality, but then all can't be, the right to equality means equality among the persons of same class. And there can be reasonable classification. So they said that, look, if a person is buying more and is offered more discount, that cannot per se be discriminatory and cannot be, deprecated, because they have offered everybody. Okay, if X is getting more because it's buying more, but Y also can buy that much and will get. It's not that they are refusing to same discount to Y and giving it to X. So therefore, on facts, they found that there's no, abuse of this dominant position. Let me tell you, the Supreme Court also went through this exercise whether Schott enjoys the dominance, and they said yes, they do enjoy dominant. It's not that this, because that is the first exercise to be done to find out whether dominant position is there or not. Then the question of abuse comes. So they came to the conclusion, yes, they are enjoying the dominant position, but whatever are the allegations, they are not proved. Okay, so far so good. This can be in any case. Then why I said in the beginning that this case is of much relevance as far as we are concerned. The approach of the court in interpreting the law, this economic laws, that on the one hand, that whether, and that is what, as you know, Tarun, that I am very fond of this law and economics, that any law which is to be interpreted and should have a particular, this economic effect of that in mind, and particularly the economic growth of the nation. And there are certain laws which are directly related. Intellectual property laws, in IBC, we know insolvency and bankruptcy code, all the effects of that, of the company, where the company should be wound up, the company should be, if the company is, facing financial crisis or resolution process, so that company is revived, it has the economic effects again. And likewise, Competition Commission is one act, how it is to be decided, how, whether mergers are to be allowed or not, whether agreements are to be treated as against the competition, or they are in favor, in the interest of the economy. This has to be kept in mind. And in the very first para of this judgment, the Supreme Court has recognized that. So therefore, that was in the mind of this the court, that any dominance per se is not something which has to be, discarded, or which has to be deprecated. Because, and now I thought, okay, I can come to that later. There's something else in my mind. But what I'm trying to say here is that the court, the biggest takeaway, according to me, which sets a very well jurisprudential principle, is that the market dominance is considered a potential engine of growth. So dominance can be those who are big players. They can bring their own equity, their capital. They can bring the substantial amount of, if they are in service sector, produce services, or substantial amount of goods, which may be good for the country. And if they are not indulging in abuse, that means pricing, etc., then naturally these will be available to the, if their production is more and the supply is more, naturally the price would be less if the normal demand and supply factors in any economy they have to play. And therefore they say that, look, and we have to encourage, another thing which is said, that we have to encourage such enterprises to attain strength through legitimate means, of course by legitimate means. So they have encouraged innovation. This judgment gives that message. Innovation is encouraged, efficiency is encouraged, investment is encouraged. So this is, according to me, is the biggest stake. Court has kept in mind the economic considerations of the country, that such enterprises, if merely because there is an allegation that you are big and therefore you are abusing, although they are not abusing, then we have to see it from this prism, that how much. So this, according to me, is the biggest stake.
Thank you for explaining in brief this analysis of this judgment, its economic implications, and also taking us through the various identifiers of competition law in terms of abuse of dominance also, and why one can be a dominant player and yet not violate the law. Interesting insight there. I'll go to Senior Advocate Percival Biliva. You went through the motions while you explained your case before the Supreme Court. What were your learnings in this case? What were you able to explain to the court? And what are the takeaways that are remaining to be shared?
So I think, Tarun, one of the more important aspects here is that there are certain specialized laws. So competition law is a specialized law. It has an economic foundation, as Justice Sikri pointed out. And the point is that knowledge of these economic laws is not very widespread, whether, you know, within the bar or in the judiciary. Now here we were lucky to have an excellent bench which set everything aside. It was a Wednesday, Thursday, and they said that this is very important. I think they realized the significance of this case that was before them. And they said, we want to hear. And I think they heard us over 6 sessions. By us, I mean not just me, but I had a very formidable opponent in, uh, Mr. Sybil. He's a very formidable opponent, and he crafted some arguments where I thought, oh my God, I had not thought about this before. So it was a very ingenious approach that we had to counter while we were on our feet. And I was also mentioned that Anu and Rahul from Anand Law, were really good in assisting me on this matter. And in fact, they were also there before Justice Sikri in the Excel Corp judgment. Now that judgment is also landmark, and I relied on that, and I'll tell you how. So essentially, when penalty is levied, it is levied on turnover. Now, if you have a company which is multifaceted, many business lines, and conduct that is found to be in contravention pertains only to one business line, Justice Sikri read into the law to say that in that case, the turnover only is the relevant turnover of that business, which makes again a great deal of sense. But unfortunately, prior to that, there was a controversy about whether it should be the turnover of the entity as a whole. So you might be making diapers and electronic chips. Now, if your market conduct is under the lens in diapers, you're paying penalty on your turnover of the entire company. So you're paying penalty even on what you earn from electronic chips. So it was this decision that clarified the concept of relevant turnover. And then again, there was the case of Rajasthan cylinders. Again, Justice Sikri, who said that, under 3.3, there is a presumption. So when you have price fixing, for example, which Justice Sikri touched upon, then there is a presumption that it causes a material adverse effect on competition. You don't really have to go into it. But he set out the principle that this presumption is rebuttable. And I had the opportunity to trace the history of this law right from the time of, somewhere in the 1800s, how it evolved. And we touched upon this as well during the, very, 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 very enlightening arguments that took place. But I think it would be fair to say that, the competition law being an economic law, it is founded on free market principles. And unless you have some background in economics and you're a believer in free market principles, I think some people have difficulty in understanding, the logic behind the law. And many times people have asked me about, what should I do to learn competition law? I say, look, read the decision of Justice Scalia in the US. He's been the one authority which has put all non-acceptable propositions on competition law, which are mired in a lot of complications, piggybacking on this and stuff like that. So, for example, the case of the blades. So, you see, the point is that if you are manufacturing a razor, then the razor is catered in a way that the blades also have to be purchased from you. So there's a very nice judgment of Justice Kalia where he explains in plain economic terms why this is not an abuse of dominance. And it's such a pleasure to read this decision, because normal reaction of a person would be that, oh yeah, there is something wrong with this. You are tying me in to buy the complementary product also from you. And this was incidentally also the principle that was the auto parts case.
Thank you for explaining this with some examples in terms of razor case and the auto parts case also. I'll go to Justice Sikri for his final comment on this topic.
Yeah, okay. Again, first I'll repeat that, look, the examining the issue from law and economics point of view is, according to me, although it doesn't say law and economics in that sense, but in the beginning also and at the end of judgment also, that is very clearly emphasized. So that was in the mind of the bench. And I am very happy because I had said so in few judgments and I have been advocating it, that the judges should keep these principles in mind. So I was very happy to read that, yes, here is the bench which is cognizant of this factor, and they have taken that into consideration. And how, keeping this in mind, how they have balanced. Look, saying, which is again, I mean, the well-established principle that dominance is per se not unlawful. It is only the abuse. And but then what they have emphasized is that, look, if the dominance is taken to gain the market preeminence, etc., that may be, there's nothing wrong in that. And while examining whether they have abused or not, Percy had touched upon that a bit, but I'll try to highlight it. And that is the second take. If first is about dominance, second is that when you analyze all those, like here, 4 or 5 these practices of Schott, they were treated as, or they were dubbed as by Kapoor, that these are abuses. But they said that we have to see effect, we have to undertake effect-based analysis, which is very essential. What is going to be the effect of that? As I said, they have found nothing, but yes. And what is more important is that this evidence-based and effect-driven methods in assessing abusive behavior, this is again a very, very good take from that judgment. And the third is objective justifications and pro-competitive benefits. So therefore, when it's not that you just go by what they are doing and dubbed it and throw it at the face of that, look, you are abusing. No, sorry. Whether there's any objective justifications behind that. So this is the test which the court has laid down. If there is an objective justification in doing what you are doing, or there are pro-competitive benefits because of these practices, then they cannot be treated as abuse. Because what is in the mind of the court again? Because if there are justification or this is pro-competitive benefits are there, then it is good for the economic welfare of the society as well as the country. Of course, another take which is for our legal word, which is more important, is about the procedural fairness, that the persons who have deposed against the person against whom the complaint is made against Schott, they should have been given right to cross-examine those. That is, but then again, I come to that regulation in in service of national interest. If it is in service of national interest, then it has to be given impetus. And in this context, I may tell you one thing. Of course, it was not argued, maybe according to Percy, may not have arisen, but I feel that that also could have been taken into consideration and could have been, that is, you see, we have, when we are talking about this dominance, etc., and as I said, that there are big companies, sometimes they contribute by way of various innovations. They would spend more on research and development, R&D. They would have substantial funds allocated for. Why companies in other countries they thrive? It is because of this reason, that they spend so much on R&D, which maybe small companies are not in a position to, but then they are. And that is why we have intellectual property laws. We have Patents Act is there, Copyright Act is there, but here let me give the example of patent only, although trademark and all other acts are there. Because when they, on R&D, it is the money is spent and the patent is taken. What is it? This is totally, if you see from that angle only, maybe somebody will say it is totally, a position against the competition, because a person who is given the patent has a right to exercise those, rights under that patent to the exclusion of all that. So in a way, you are giving monopoly. Why that other competitors cannot make use of that patent? They cannot copy that. But why we give that protection? We give that protection so that people or those industries or whosoever wants are able, that they should be encouraged to spend and to innovate. Otherwise, if I have innovated, I have by spending, say, crores of rupees in my labs and giving to the scientists, and over a period of 10 years, I have come out with some very good product, or even within a particular product which is known, but with my, improved upon that with my technology, and tomorrow it is available to all, then why should I spend this crores of rupees or hundreds and thousands of crores and give all to, if anybody and everybody can utilize that. That is why the patent is given. If it is life is 10 years, 15 years, 20 years, whatever, during that period, I have monopoly. And Competition Act very well recognizes, I think it is Section 3, subsection 5 of the Competition Act, which says that those who are having, that will not be treated as, against the competition. It is, so therefore, this is how the balance is maintained. And this is what is captured in this judgment indirectly, although without reference to the IPR. They have said that they have mentioned about the Schott's, this company's antecedents and how they have been spending so much on R&D, etc., which otherwise would not be available for the welfare and the growth of the economy of the country. So again, therefore, I say that according to me, that's the best approach which the court, and this is this approach which I really praise a lot, rather than simply an outcome of this case.
Thank you for so beautifully explaining this, including the whole concept of surplus money that companies need to invest in R&D and make products better, which on a very larger scale may take the human race forward, but at the best it gives better products to people. Congratulations, Percy, and like to a fine judgment by Justice Vikram Nath and Justice Prasanna Varay. Look forward to more such judgments from them so that we could sort of take them up for the larger good of the industry and the people. I'd like to thank Justice Arjun Kumar Sikri, Senior Advocate Percival Bilimuria, for joining in this one. It was a pleasure discussing this judgment. Thank you so very much. Thank you.
Thank you.